Buenos días.
Good morning to everyone, and thank you to those who are joining us. To honor punctuality, we're going to start this first panel for today. Now I leave you with Roberto Guerra. He's a partner of Herrera Abogados, Brazil, and we'll have the introduction video. Consumer and Metaverse challenges from other reality. María de Los Ángeles Lombeyda, AVL Abogados, Ecuador. José Roberto Herrera, Herrera Díaz Abogados, Colombia. Moderator, Alberto Guerra, Guerra IP, Brazil. Hello, good morning to everyone. And first of all, I would like to thank all your presence for changing the warmth of your rooms, for being here after last night's party. I am sure you won't regret it because we have two talks, two very good panelists. I also want to thank ASIPI the opportunity for being here to help this for helping this association that is very important for me. I congratulate ASIPI for this topic, Metaverse, because not all of us know about it, and there's no way back. Metaverse is a must. We have. I was listening to the panel. It was a Metaverse entrepreneur in Brazil. I think the precedent was there, and it called my attention some data which is very impacting, which is related to today's panel, that in 2050, that we're not too far away from, 50% of the world consumer market will happen in the metaverse, to show the importance that Web3 will have in our lives and in the lives of our children. So for this panel, as Dr. María de Los Ángeles Lombeyda, and we have José Roberto Herrera, PhD, and before giving the floor to María de Los Ángeles, I would like to refer to her curriculum. María de Los Ángeles Lombeyda, she's attorney of the Pontificia Universidad Católica Ecuador, Master in Intellectual Property, University of Alicante, Master in Law, University of Valencia, Doctor of the University of Valencia, and Professor of the University of San Francisco de Quito since 2000. She's a partner of AVL Abogados. María de Los Ángeles, the floor is yours. Thank you very much. I wonder if you can hear me perfectly. And good morning to everyone. Thank you very much, Alberto, José Roberto, and to ASIPI for this invitation. And I thank everyone here because I know how valiant you are after this party we had last night. And I would like to start my presentation and ask you, why will we speak about metaverse and consumer? And the answer, and the only answer I'll be able to share with you today, is because metaverse will be across the board. I don't know if it'll be in 10, 15, or 15 years or 20 years, but it will be across the board. And allow me to stand. I'm a professor, so I have this professional deformation of standing for my students not to fall asleep. So why do we have to speak about metaverse? One, because it's cross-sectional. And why do we have to speak about metaverse? Because it's going to be in 10, 15, or 20 years. Well, because as attorneys, we have to start discussing this from now, from this moment when it's a concept in construction. And here I want to say that I'll give many ideas, very little answers, and many of these ideas will be of conflict, and it'll cause for you to hate me. Not for you to hate me, but I want to make you think, and I want to invite all of you to take off our suits of attorneys and challenge you to play a role that we don't assume many times, despite having to do it, which is assuming the role that we're all consumers. Every time we buy a bottle of water, we're consumers. When we acquire software, we are consumers. And when we go and purchase in the metaverse, we will be consumers. And why do I want to invite you to assume that role? Well, because only when we leave our comfort zone, when we think out of the box, is when we have disruptive ideas, when we have creative ideas. And those creative ideas will allow us to be better attorneys and give better solutions to our clients. And I want to start, or actually end this introduction with a phrase that called my attention, which we must have present, which is what happens in Metaverse doesn't stay in Metaverse. And it's interesting because it's true. It's funny. And I want to share with you some numbers that called my attention when I started my research. In a recent study carried out by European Union, it stated that the level of knowledge of metaverse, of notions of metaverse, was approximately 34% of the population. But what called me most the attention is that 32% don't even care what metaverse is. For sure, these numbers will change and they will go in crescendo, but that's the case for now. And this is the case now because it's calculated that for 2025, the economic assessment of metaverse will be of $82 billion in 2025, less than 3 years from now. Another number that called my attention, and I must confess, it called my attention because of metaverse. I knew very little or nothing a month ago, which is that the Zepeto platform that I hadn't heard of until this investigation, I hope you have, is a metaverse platform of South Korean origin. This platform has 200 million users, more than 200 million users, more than the China population. Of those 200 million are youth. And of that, 90% is outside of South Korea. And I want to refer to it because it'll help us see other phenomena, which is vulnerable consumers on one hand, and on the other hand, dislocation. And I know I invited you to take off our attorney suits, but only to give a context. What is the treatment of our consumers in the country? First of all, 90% of constitutions in the region preserve the rights of a consumer as an assurance. This means the law has to be developed, and consequently, 95% of the countries of the region have a law in defense of the consumer. And 100% of these laws treat or regulates everything related to electronic trade. And going now to the consumer, I will mention certain concepts that I believe are important. And the first one is how to define or an approach to the average consumer, which is something we have heard about a lot in brands and trademarks, but not only in trademarks, but also rights of the competition, much more than what refers to consumers. And this average consumer profile allowed me to take one of the most famous rulings of the European Union, which is you approach the average consumer and you say they're averagely informed, reasonably attentive, but you must consider also social, cultural, and linguistic factors into account. But what calls me most the attention, what I want to share with you today, is the fact that the Court of Justice of the European Union speaks about vulnerable consumers, and it states that there must be special protection to this vulnerable consumer. But what is a vulnerable consumer? And here, allow me to read because I can't say it out of memory. And I'll quote the definition given by a Spanish professor. And she says, the person who has personal or sociological characteristics, and I'll emphasize, that impede that person to reach that degree of knowledge of products, services, and of the conditions of contracting. In other words, this person doesn't have a clear knowledge of the characteristic of the product, nor do they have clarity on which are the ways of contracting. And I want to ask you that together with your coffees to remember this concept because it will serve us going forward. And here I want to quote or profile consumer of the Andean community by being Ecuador. It's very close to my heart. And it speaks about three types of consumers. First of all, the average consumer. Secondly, the selective consumer. And third of all, a specialized consumer. The average or medium consumer, and we go back to the definition of the Court of Justice of European Union because that's where this ruling comes from. The Andean community is the consumer that is informed, reasonably attentive. However, their level of attention depends on the product they're acquiring. So if you're buying a pencil or a pen, they will have a level of attention that's different from buying some type of medication. And it makes sense. Selective consumer are those who have a little more information, that know the product a little more, that knows certain characteristics and specificities of that product. And additionally, do their purchase based on a positioning of the product or based on a status. So we as IP attorneys, this makes sense. And specialized consumer are those who have even more information, that are not just pleased with the information given by the supplier, but they do additional research. And we'll agree that there are very few specialized consumers. So here comes the first question. How is the Metaverse consumer? How do they look? And this is my answer. I have no idea. However, what is important is that we must establish what that consumer is. We must determine if the average consumer of this physical market is the same average consumer of this digital market, of this metaverse. Is it possibly an average consumer? Is it a specialized consumer? Is it a selective consumer? Or is it instead a vulnerable consumer? I would love to give you the answer if you ask me in 25 years when I hope to be retired in a Caribbean beach. I would give you an answer, but not for now. And you heard me initially that I said that we will share clashing ideas. And when I spoke about this with my panelists members, they rose their eyebrow, and it's because many attorneys say that metaverse has to generate a new social contract. That a social contract of the 17th century wouldn't be applicable to the metaverse. And Alberto was saying we don't even apply well the social contract at this moment of the 17th century. How do we plan to establish a new social contract? Well, that's what attorneys say, that we have to apply a new social contract, forgetting what Rousseau had said, or Hobbes some centuries ago, to refer to this new contract. And it's a new social contract that has to come not from the citizen, but from the consumer, because it's a consumer who is the engine of the economy, promoter. So here I ask, who is a person who buys a product identified with a trademark, whether it's a digital market or virtual market? It's a consumer. The consumer moves the economy. If there wasn't a consumer, there wouldn't be market in any stage. And we have to have that clear as attorneys, where your attorney had it again and take it off again, and let's be consumers again. This means we have to define new concept. I was saying that we must define new concept of consumers, but it doesn't stay there. We have to also work on new laws. We have to adapt our laws for the metaverse world, but additional to that, we have to redefine our roles as attorneys. Will we be necessary, or we will not be necessary? And here I do have the answer. We will be necessary, but we have to redefine our role. And here I launch an idea that can cause reactions. Terms and conditions must be the new laws. Terms and laws given by the platform is what must rule our relations in the metaverse? Only the terms and conditions? My answer is no. And and the platforms might say this lady is crazy. I think she danced too much last night, but I don't think so. I did dance, but the answer is no. How should we handle conflicts? Should we manage these only through the terms and conditions, or must there be another methodology? I would believe there must be another methodology. But what I am sure about, because as I said, the social contract is not completely clear, and I share the concern with Alberto and Jose Roberto. And what there must be is a new governance, and we had heard this in previous talks. There has to be a new governance which is proper to the metaverse, and I'll speak about this in the few answers I can give. So we have before us the challenges as far as consumer protection. On the one hand, we have delocation that we referred to just a moment ago. We have transnationality. We have information symmetry. And once again, I refer to the vulnerable consumer. And as far as delocation, here I want to bring this concern, and then Jose Roberto will give many more examples. It turns out I love to buy clothes. When I'm stressed, when I'm not stressed, when I'm happy, when I'm not happy, I buy clothes. What happens in that buying clothes, in that eagerness, what happens if in this that I want to buy clothes, the metaverse fashion comes in and I acquire a marvelous dress from a Russian designer that exists, and I would like to share the name, but memory at this time of the morning, I can't remember a Russian name, but I acquire a product from a Russian designer in a South Korean platform. What laws apply to that? Who is the competent judge? If I apply the terms and conditions, more than likely it'll go against the indubio pro consumer that applies to all our countries. So what's the relationship? I don't have the solution for this because, as I said, I bring many questions and very few answers. As far as transnationality related to what we said previously, I share with you a concern. In Ecuador, international private law, which is core for these topics because it establishes the connection point. Private international law in Ecuador applies to the Sanchez Bustamante a code which is over a century old. How a code that's over a century old can face the challenges of cyberspace. That Internet 2 gives us even less Internet 3 and the metaverse in Europe, which has much more developed the connection points, private international law. They're working like crazy. And I'm asking you, dear colleagues, what are we doing? You saw, I said I was going to provoke you. And the third point I want to share with you is a symmetry of information, which is a severe problem we have in consumer protection because consumers as such, and that's why they're considered the vulnerable person in the consumption relationship, doesn't have all the information the provider does have. Actually, it only has the information given by the provider. How does this relevant in metaverse? Let's speak now, to speak in 5 years, in 10 years. The asymmetry of information will possibly be a gap, or it will create a much more important gap. And this takes us to the last point, which is the last of my concerns for now. I can assure you there are many more, which is the vulnerable consumer. And here I want to share a study from 2016 of the European Union, which establishes that 75% of consumers in Europe have a degree of vulnerability. It's not 5%, it's 75% of the European consumers have a degree of vulnerability. If we recall that vulnerable consumers are those that don't have completely clear what the product is and don't have clarity on the ways of contracting, I want to ask you, who wouldn't then be a vulnerable consumer in the metaverse? And I would like to make a survey, but I'll just leave it there. But I'm sure it's much higher than that 75%. And here are the recommendations, which are very few answers or advice I can share. And the truth is, as a professor, it's more homework for you to take. We have to work with new concepts. We have to define if the average consumer of the physical world will be the average consumer of the digital world. That's our first task. But we must also redefine vulnerable consumer. And we must have clarity that this is about dynamic concepts, which more very possible that we now understand as vulnerable consumer in the metaverse is not the same as in 30, 40, or 50 years, but we must start working. We are already behind, and that's why the importance of speaking today about metaverse. I'm not a friend of having many laws. I believe we have to have few but good laws, but we have to work towards that. And for this, we have to research, and that's our role as attorneys, as legal operators. We have to study and we have to discuss. And for this, we must speak about terms and conditions. To my judgment, terms and conditions cannot be the law that regulates the metaverse. It has to be a part and an important part. I completely agree with that, but it cannot be the only thing. There must be national regulations, but especially international regulation, precisely because we're no longer in a globalized world. We're in a delocated world, which sounds like a terror movie, but it's not. So we have to work in this new state and regulation, international, supranational, where there has to be co-living between the public and the private. And here you might say I'm quite naive, and you might be right, but we have to know that terms and conditions will exist, but there has to be harmonization, and that harmonization must be at global level for it to be effective. We have to sit and speak about cyberspace governance, which might sound real, but it will help us make this transition to an Internet 3.0. And here I'll sound like a mother hen, and that might be the case, but I think it's our role as attorneys that to have the moral and ethical and philosophical values present, especially if we have to create a new social pact, because only when we use these values we can well advise our clients. We could be the attorneys we must be, but above all, we are overseeing the well-being of our children and our environment. And so you can see I'm not the only one thinks this. I want to share a final phrase from the CEO of Telefónica in Spain. He says, if we allow for each great technology to create its metaverse, each one will be its own country with its own currency, with its own rules. We have the obligation, this is the invitation, we have the obligation to understand these new worlds and establish values. Thank you very much.
Thank you very much, Dr. Lombeyda, for your excellent presentation. The Defense Code of the Consumers of Brazil has as a principle the recognition of the vulnerable consumer. These conquests that we have won, that we took us 300 years to issue or to achieve, we cannot just leave them behind because of a new virtual environment. We have to adapt ourselves. So our next panelist, José Roberto Herrera, known as Berto, and now in this panel, Metaverto. He's going to talk, give us a presentation of some practical cases of this very interesting topic. He is Metaverto, so is the director and partner of Herrera Díaz Abogados. He has an MA in the Institute of NIC Alemania. He's a professor and speaker on intellectual property and entertainment rights, president of the Committee of Entertainment of ASIPI, and former president of the Copyrights Committee, among other important committees that he has led and other associations. So, Metaverto, the floor is yours. Good morning, everybody. It is a pleasure to be here today with you and to be with you, María Los Ángeles and Alberto. And I would like to thank all of the public, the audience, for being here and after such a wonderful party offered by the Costa Ricans, the Ticos. So I am here to talk about how as attorneys we need to identify issues related from the consumer perspective, not so much issues related to intellectual property, although there are some cost-cutting topics, but to identify for specific issues from the consumer perspective, being very specific on a legal, from a legal point of view as well. The first one, as well has also been mentioned, you can buy as such, no metaverse actually exists in such. So there are many fake news that the metaverse as such is not great, is going to exist, and the debate is whether there will be many metaverses or just one. But obviously, we can already start buying lots or pieces of land or real estate. I really don't know if that's the right word, or personal property in a platform called Decentraland. This is one of the first cases in which, as I am mentioning here, consumers can buy a piece of land that, and this is news from 2019, and even at that time, with the cryptocurrency, if we transfer it to dollars, it was exactly the same as expensive as buying an apartment in Manhattan. So you can imagine how expensive it is. And today you can go to several platforms to check how much of one of these properties cost, and the prices are still very high. But of course, the legal implications for this, what are they? The first one is that when you buy an apartment in your countries, you have to register in the land registration of your country. First, you have to engage in a public deed to go to the notary public so that it can be actually recorded, and there each of our countries has deed registration office. But what happens in the metaverse, we have the great advantage that this is done using blockchain, so there is a traceability or tracking, so we have a chain of custody, and what we happened in the past in the land property, we knew who was the owner at a certain time. So this way, of course, is a lot safer because it makes the whole issue more flexible because of the ready-made contracts or smart contracts, or however you want to call them. But the first problem is that we already have seen that these contracts have been hacked, and one of the first one, not about the property or the ownership itself, but it happened with Seth Green. This actor and producer bought these NFTs, which are the board games, which is the typical case of the NFTs that you see, these monkeys. And he was going to use these NFTs in an audiovisual production. But he was a victim of phishing, which is one way of stealing information in the digital world, to have a phishing scam where you go to click on the bank and you enter your PIN, but it was not the bank, it was a scam. And this is what happened to him. He entered his password, and the thief was able to sell the NFTs. And today, legally speaking, he cannot use those board aids, these NFTs, for the audiovisual production that he wants to make. What he alleges is that they were stolen from him, but in the blockchain, the buyer who bought the NFTs is the legitimate owner of the NFT. So this is a huge debate today, and he's trying to recover his NFTs, but it is a current debate that despite the safety or security that blockchain represents, it's really not as safe or secure as we thought. We are not guaranteeing, obviously, absolute security. And this is one of the main problems that has arisen. Of course, this does not guarantee that these transactions are going to be 100% secure. And the other issue, of course, are the mortgages. Today, there are people who are securing a mortgage on a real estate as if we consider it as a pledge or as a real estate. So they are using this to secure their debts. And in many countries, they have real estate and intellectual property rights in which I can secure the payment of a debt with a copyright on a brand or a trademark that I have. And this is already happening in the metaverse as well. It used with the NFTs or these intangibles. And what happens, that was the first problem, the issue of security. The second problem, as Maria Los Angeles mentioned, who responds when anything of this happens? There are many situations that can happen and that affect the consumer. For instance, the issue of violations to intellectual property rights, in which not only the holder of the ownership is affected when there is a violation of IP, but as a consumer, if I buy a fake good in one of these platforms, of course, I am also going to be a victim. Also, the whole issue of data, as was mentioned yesterday, everything related to personal data that could be stolen or could be misused by the owners of the platform. Everything that has to do with the image rights related to avatars. It is very often that consumer guarantee, if I buy a good that I can complain that in most countries is a consumer right that I can complain or to and get a refund if I don't like the product. Anything about fake advertising or false advertising, the sometimes there are many these blue boxes that are disguised, which are basically targeted to minors, and they are gaming or that affect the consumer. And of course, child pornography, defamation, slander, and everything that happens in the social media, but that it's going to be even exacerbated in the metaverse. And here I'm mentioning an actual case. This was the platform of Meta, where this mother, she wanted to join this platform to see how it worked, to know what her kids were doing. And she created an avatar. And in the news, it says that she declared that she had been raped. But obviously, legally speaking, there is not such a thing as virtual rape. In our criminal codes, do not classify this as a crime, but in many countries they already punish many these kind of behaviors through digital harassment, or what they usually call grooming. And this, of course, this is another of the risks that are consumers are exposed, and this is another problem that I wanted to present. This was the second issue. The third is the platforms. What happens with projects in the metaverses? Are we going to have a centralized metaverse, or is it going to be decentralized? In the case of Central Land, as the name says, it is obviously related, where it's a decentralized platform in which there are different users who ultimately are going to be dealing with the consumer. But what happens with this? This is a great debate, because as such, there is a big question that we have to ask. Is there going to be one metaverse or several metaverses? I believe there should be only one metaverse rather than several universes, as it's saying the planet Earth and also Mars or something like that. Because the metaverse, if we go to a parallel universe, it has to present an interoperability that makes consumers feel safe with clear rules. So this is a great question that we have today. And I am mentioning here not to go in depth, but I am just sharing with you the slides. I can share them with you in the past, where all of these terms and conditions, this disclaimer of responsibilities. If you read these terms and conditions, basically are not liable for anything. And obviously, when it is centralized, then there is some liability that is a little bit more beneficial to the consumer. But in this case, decentralization, if you actually read these terms and conditions, liability is almost non-existent whenever a problem arises. So one of the risks that you can see as you still believe that the decentralization is nice because it is more democratic, because there are more partners, but ultimately many experts on this reposes a highest risk of plutocracy in which power is going to be in the hands of the landowners, not on the owners of the it is not going to be a democratic voting society, but relevant decisions, if we accept all brands or trades that we advise to be accepted in that piece of land or not, will be in the hands of the landowner. So the property will be in the hands of just a few. This is one of the other problems that has been arising. And going beyond, if the metaverse is going to include political decisions, the governance risks are very high, and this is why all of the countries are interested in this topic and studying it, because this is going to be debated greatly. I don't know if you have said watch the movie Ready Player One, which deals with a metaverse, and decisions, of course, that you see that end up being on political power are go along these ways. Now, coming to our reality today and talking about power and decisions that are going to be relevant for the consumer. This is the case that we see with Elon Musk. I don't know if he's going to buy Twitter or not. They have been talking a lot about this, but one of the reasons that this is concentrated, or that the power is in the hands of only one person, who is someone who is one of the richest men in the world, is if I own Twitter, I am going to accept. I am not going to censor the platform. I'm not going to block any accounts. Anybody can write whatever they want to literally say. And of course, I find this a very serious problem, because in the case of Donald Trump, that I believe ultimate Twitter's decision, there could be many people who don't agree with me, but I think it was very positive to block his account, because many said, well, that has to be decided by a judge. But I do believe that in the current world there has to be a limit when dealing with some kind of content, because the rights cannot be absolute, the freedom of expression cannot be absolute, and this is one of the current risks. But going back to the metaverse, who is going to respond, who be liable? I want to show you the evolution of liability in the platforms. First, we had the liability of internet service providers, in which in many countries there are procedures from the European Union or the United States. In the United States, the DMCA includes the process of notice and takedown, where I can ask the platform to block some content because the content violates the laws, and I can go directly to the platform and then comply with certain requirements. And of course, there are exceptions whereby the internet service providers are disclaim their responsibility, and this is positive for the countries that have implemented this. In Colombia, unfortunately, we have not been able to implement it. The Congress has not done so, and this is great criticism, because in anything related to copyright infringements or trademarks, or we have to go to a judge, and that takes too long to go to the court to just have some content removed. So what happens in Europe is that maybe the evolution so far, there are cases in which directly the platform, not just again the internet service providers, but many other platforms such as Mercado Libre or service platforms in the cloud-based service platforms, you can ask to have them remove content, and they can be liable. And these are requirements in which there could be some actual liability, according to the European Directive Digital Market, that said that recently that it violates the freedom of expression, because Poland uh, sue the European Commission because of this directive and say that it doesn't violate the freedom of expression, and they accept this legislation. And I think it is excellent because today, if we go to the court, then that it will take 5 years, proceeding will take 5 years. There is a nightmare because I have lived through it, because trying to protect the customers' content, because we can come and tell them we could do it, but proceeding will take 3 or 4 years, and then there will be an appeal, and it will take another 4 years, and obviously this discourages our customers. So thinking that there is a risk of infringing our freedom of expression right, this is the ideal legislation. Of course, there can be many opposers to this, but this, in my opinion, is the ideal legislation. And obviously, as Maria Los Angeles was saying, in the metaverse, the issue of extraterritoriality and the issue of legislation that is 100 years old, we do have the same issue in Colombia. When you study civil law and you look at the issue of liability, it is simply terrible to come to the point and apply it, because it is totally outdated legislation. And I don't want to say that we have to regulate everything, but there has to be at least some more specific legislation that can be applicable to these kinds of issues. But so far, what is being applied the most, is that the ideal solution is arbitration and the friendly composition. And this is the one of the platforms court, and which has been based in blockchain, and this is one of the first platforms that already exist for to resolve consumer issues. And for many platforms that want to sell their goods and services in the metaverse, we have this other company that, especially what I want to stress, is that it helps them a lot to prevent phishing, which is what actually happened with the NFTs being stolen. So this is another one that you're welcome if you want to check these slides to learn more details about these projects. And also want to tell you a little bit about the Colombian case in the data protection law and consumer protection law in Colombia. I believe it works well. And although the platforms, current platforms such as TikTok, where they don't have a company constituted in Colombia, but because they are in China, the legal protection data has already ordered them to follow certain laws that they are not complying in terms of protecting personal data in Colombia. However, the court has already warned them that they have to comply with the Colombian data protection law. But sometimes, as I mentioned here, this is just like raising the flag. They are condemned, but they don't follow the rules. So it is. These are some of the problems that we're going through, and they will even become exacerbated in the metaverse. This is another issue that is also very important, interoperability. Ideally, there should be only one metaverse where I can create an avatar that I like, not necessarily it has to look like me, physically speaking, but the idea is for the consumers to be pleased with their avatars. But the main problem is that Meta creates one metaverse and another platform creates another metaverse. As a consumer, from a point of view of consumer right, you have the right for this to say that this is personal data, and we should be allowed to use our avatars in all of the different platforms. And this is what happened with cell phones. I think in all our countries we have number portability, or in which if I am a Claro client, I have the right to keep my cell phone number if I move to a Moist or another cell phone operator. And this is what we would like to have in the metaverse, to be able to create an avatar that can be used in all the metaverses, because it becomes part of the branding image, then part of data, personal data that can be used in different platforms. And as you know, emoticon, the one that creates an emoticon has intellectual property, and the idea is that these emoticons can only be used in all platforms. because although they have intellectual property rights, the one that organizes the metaverse has to have license to be able to guarantee these consumer rights. If I use WhatsApp, but I also have iMessage, sometimes I cannot use all of the emoticons that I want. So this is one of the main discussions and debates going on today. And finally, we have issue of money laundering. As you have seen, this has also represented the crypto assets, which is a source for money laundering. And this is a picture, it's a conference, I think it's taking place today and today, where they are going to discuss the issues of money laundering in the metaverse, which is another risk for the consumer, because if I bought a piece of land from a drug trafficker, we are saying, is this a real, if it is a real estate property, so my money, the domain could be seized because it comes from an illicit source. So it has been verified that a lot of the dirty money is coming to the metaverse because it is easier to hide it. And to conclude, I would like to stress the fact that although we are talking about very advanced technologies, we have to study the issue of technological issue in depth. The truth is that until a while ago, I understood how blockchain works, because you read and you say, well, yes, the advantage of blockchain is that it certifies who owns what, but actually understanding the technology for us as attorneys is very important. Today, we have to be aware and study this topic, everything that is called the meta web threads, it says confuse and you will be king. This here sounds like fad words, metaverse, and it sounds nice, but really understanding that is different. I think this is not just a fad. Repeating and reiterating what Enrique and Ricardo have mentioned in this topic, this is definitely, we do need to study these topics and identify these technical language, these technologies. And this is why I would like to pose a phrase from my mention that attorneys have a perpetual have, life because they have to be students forever. And so we need to study and understand all of this. This is it. Thank you very much for your attention despite last night's party, which was very good.
Muchísimas gracias, doctor Herrera.
Thank you very much, Dr. Herrera. Very interesting presentation. You have talked about actual cases that are occurring in the virtual world, but are very real, that we need to have a legal definition because there are many topics, such as the case of crimes, that need to be very well identified in the digital environment. I do believe we have a problem right there. So I open the floor for QA. If anybody has a question, please go ahead. We have 4 questions. Sounds good. Good afternoon. For María de Los Ángeles, I wanted to ask you a question about reasonable consumer asymmetry of information and localization or delocalization regarding the Andean community. You have mentioned that we have an average consumer, the reasonable consumer, or specialized for competition, which has been adapting in the Andean community to say that it is reasonable, but it is average than specialized. So now my question is, the vulnerable consumer is a legal construction of the European Communion, European Union, and it's a concept that came about after the contractual clauses, because in credit cards, for instance, it is clear that there are abusive clauses in the metaverse. Speaking about the metaverse contracts, are there abusive clauses, or the asymmetry has to do because of ambiguity, extension, and technicism or technical language? Thank you, Carmen, for your question. This is a test question as a good professor that you are. Actually, vulnerable consumer is a legal construction that comes from the courts that is presented or came about because of problems that started when dealing with adolescents. Talking about the abusive clauses that you mentioned, I think more than abusive clauses, there could be terms and conditions that are either too extensive, too long, or I can invite you. Who of you have actually read all of the terms and conditions when you join some social media platform? If you raise a hand, I will buy some drinks for you. Dr. Chavaro, Pedro, no, I don't trust Pedro. Ricky, I don't trust you either. I don't believe you. What I want to say is that these are terms or conditions that are too long, that are usually very vague. Sometimes they use technical language, and they could be long, vague, and they could also have technical language. So I don't know what they want to do, but sometimes they discourage people, in this case the consumer, to read them. So this is why I said in this particular case, whether for the metaverse or even for cyberspace in general, we can all be at some point, more often than we want, we can become vulnerable consumers. Thank you. Thank you very much to both of you. This question is for Sir Roberto because it's related to the Colombian law. The question is, you talked about money laundering. At this time, the Colombian law has some important restrictions about transactions using virtual assets. Do you think that based on what you mentioned, that consumers will have a higher standard when doing transactions in the metaverse? Because at this time, consumers, the average consumer, doesn't have the obligation to think about money laundering or asset laundering. Will that change in the metaverse? This is your answering your question is a bit difficult, I think, but I would believe that we will continue in the same standard. But I believe that authorities are not going to be as flexible when has been shown that a purchase of a good, it has an illicit origin. So I am not sure about the pieces of land because with the extension of domain that buy that, and despite this, consumers are hurt because in countries where there is unfortunate, there are traffickers saying you have to verify who you are dealing with because you bought an apartment, ends up sometimes losing your money. And of course, there are also insurance, but I believe that the standard answering your question is not really going to change too much, although we do have the issue of the consumer that is not, as we mentioned yesterday, it is not required to have a very well-versed consumer. When we talked about patents, that we have the examiner who is a person that has to know the subject matter. In this case, consumers is a non-expert, but I do feel that this is not going to be as flexible. It's going to be continue being similar to what we are saying. But I could be wrong, of course. Well, thank you very much.
Questions more related to centralized metaverses, especially terms and conditions, when it establishes that before any violation or whatever, the court and establish, for instance, in the California court, in the case of a consumption relationship, I understand that this has no value. It's a public order rule. So I would like to know how your jurisdictions take these clauses, if you consider these not being applicable, or on the other hand, the freedom of the parties to establish the jurisdiction and legislation that applies. This question is for who? For any one of the speakers, or for both? I won't. You always make the most difficult questions, but to answer what happens with those type of clauses and terms and conditions in the case Colombia, for instance, with TikTok, with the arbitration, the superintendency of trade and industry, they thought they were breaching the protection, data protection, so they were charged, and I think it was a good thing. But carrying out that charge for them to comply, I think it's very good because TikTok was ordered to do this. But I believe that the ideal way in this specific case is and there's an authority in Colombia which is the Ministry of Technology, Information Technology, MINTIC, that even will block their domains if they're not compliant with the regulation. But this really won't happen. But at the end of the day, is that to resolve these type of issues, what the authority needs is to have the power to be able to sanction them, because as you said, it could be just something fathom. So when they say, hey, we salute the flag, I don't know if this term is used anywhere or in all the countries. In case of a Ecuador law, we have a consumer protection law. However, the effective part is very efficient, or the enforcement. And following the example of Jose Roberto, we can sanction TikTok, but it won't be enforced, and that's where the law becomes dead word, and it's worth nothing. And in terms of conditions, is what prevails. Can you hear me? I have a standpoint that could be simplistic of these topics, but when we speak about indubio pro consumer and we speak about adhesion contracts, I consider that many of the smart contracts we currently see that are self-executing at the end are contracts by adhesion. And therefore, the legislation that applies to these contracts in favor of consumers perfectly applies in any of our legislations. The point is the execution of these. You how do you see the possibility to enforce that right of the consumer, and before who? Something I wanted to add was what happens with the domains, which in WIPO, that panel, there was a panel to resolve all these controversies. And I think it's the ultimate solution, which is for to have that enforcement, where, for instance, we order to we would close that domain if you don't comply with the regulation. But this is subject to the will of the parties to resolve these controversies. But I think a more local justice applies, or local authority is how I see it. It would be a solution. We like to answer. I share that, and it's precisely as I said. We must speak about consistency in terms and conditions, and international and national law, and we have to recall that it relates to jurisdiction and the limits we know in our countries, and think that the metaverse will be cross-section, and we, in this across the board, we have to think about new ideas, and as Roberto said, it's very timely. We have to see each case specifically. First, you owe me a drink. I had to read. Don't tell if you're the attorney. So I didn't read the small print. But I had the opportunity to look into that. You were just discussing with Roberto that terms and conditions in social media becomes almost their own jurisdiction of social media, but that we will see increasingly in Metaverse. And Fabrizio, we're asking what validity will it have? Well, in Metaverse, it'll have all the validity because it could be applied there and then. So, how do you see the fact that these supra jurisdictions or virtual jurisdictions can affect the reality? Could there be any charges, or if you simply accept the rules of the platform, you are subject to a jurisdiction like if you were to visit a country? Well, it depends on who we are referring to. If we're speaking about the consumer, they would probably feel subject, although they shouldn't. But let's think about the provider, the service or product provider in this platform and how the platform would look. The way I see it, I'm very pessimistic, but I think the platform will have the power, and that's where we'd have to uh, specify that's a concern. That's why I'm saying that the consumer in this three-part equation would be the most vulnerable. We have more questions, Ricky. Thank you. Very interesting panel. And by the way, I I have that same challenge. I have a client or several companies that have stores in Zepeto, Sara, Ox, Levi's. And when my children saw there is Zepeto, he said, "What are you into?" And a very specific question for Metaberto. This topic is called Metaverse. We can change your badge and we can update it. But as far as domains, the Metaverse, obviously they're based on blockchain. So the structure of the URPs does not work because you have no one to tell to transfer the domain because this is in blockchain. So a solution would be to burn it or disable it or for the owner of the brand not be able to use it. I don't know if you have any ideas in this regard. Specific question is, it's not a question, it's a comment. It's to see what you think going forward, if there will be any uh, alternate measure. Because I remember many years ago in the CP Congress in Paraguay, where the ERPs didn't exist, so we were talking about how can we regulate internet. Obviously, the internet providers didn't want regulation. Same thing that is happening now, but we arrived to that solution. Obviously, the internet developers didn't want the mechanism, but the mechanisms, ERPs didn't exist. So we had to create a balance. I think the ERPs were a balance. In Metaverse, there's that additional challenge, which is blockchain. So I don't know if, have you looked into that topic? Do you have any comments? Well, my thoughts before what I was saying of the big issue that there are these purchases that represent a lot of money in those properties. So the big risk with that is hacking or these phishing attacks, which where many people can steal and bring this to the legitimate buyer, like these NFTs. I don't know regarding properties or lots, but I think the same thing would happen so that legal security would be attacked at that event, despite blockchain guaranteeing the traceability. And beyond just the cases we see in real estate, where they say that a purchase sale simulation of people who have properties that were fraud. But I think that is a risk that despite having blockchain, it's not 100% safe. I think it's safer, but we're also exposed to that. So that's my reflection. I wonder if that was actually the question. Kind of. We have some more time if anyone has any other question. So I told you you wouldn't regret it. That even having to wake up early, I told you wouldn't regret it because we have very good speakers. I thank you all for your presence, and we this way close this panel. Thank you very much.